Um, what do we move on to now? We had another good one.
There's the election lawsuits. There's McCloskey tampering. There's Rittenhouse extradition. There's several.
Let's do, well, Rittenhouse extradition, I guess, is going to be a relatively short one, right?
Yes, it's what happens when you have incompetent defense lawyers doing work for you. So the way there's two things of extradition, folks. There's extradition between the United States and a foreign nation, and there's extradition between the states inside the United States. The former, extradition between the United States and foreign nations, the U.S. Constitution can come into play, foreign constitutions can come into play, a wide range of legal principle, international law can come into play. That's why Assange has a wide range of defenses that you would not have available to you in an intrastate extradition between the states of the United States. That is governed by the extradition clause of the United States Constitution, which requires that if a state requests the extradition for a crime, then the governor does it, then you have to extradite him, period. Your only defenses in that context are that what is being defined is not a crime under the extradition clause because it's not a crime in your state. Or the second is that identity, that the person that's being sought is not you. Or third, that the governor, in fact, hasn't made the demand because some formality that's required for that demand to be met has not been met. To establish that and that's basically just on the papers analysis. So they filed on the literally like the last minute, the last day that they could file, they filed their habeas petition for Rittenhouse. The first argument is a technical one, is that there was basically, they didn't get something approved by the magistrate properly. They didn't take the oath before the magistrate, even though they signed it before the magistrate. A technical issue that can be easily remedied by Wisconsin, but might afford some remedy in certain contexts. But their main argument was that citing Seventh Circuit case law on U.S. extraditions with foreign nations, that the Fourth Amendment can be raised as a defense, and that substantively it's a violation of the Fourth Amendment because the arrest warrant doesn't meet probable cause standards because he was acting in self-defense. The problem with that is that is not allowed in intrastate extradition cases. The United States Supreme Court ruled more than 40 years ago in Michigan v. Duran that the Fourth Amendment does not apply, that you can't do any analysis in an intrastate extradition because it's between the states. The only thing you can look at is what I just talked about. Is there a crime? A period is what's defined in the affidavit constitute a crime in your state. And there was a defense there that I talked about way back, which was that self-defense may be different between the states. So there could be an argument just based on what is in the affidavit, because that was a very unusually written probable cause affidavit that included the exculpatory self-defense facts within it. They didn't pursue that at all. Instead, they said, hey, let's use the U.S. foreign law jurisprudence. Didn't even tell the court that there is a governing decision on this issue, that this and the Fourth Amendment does not apply in interstate extraditions. So the court's going to immediately think that he already probably was thinking this, that because of the delay in their submission, their delay in getting documents and information, and their just behavior in general. Indeed, they didn't even ask to speak to Rittenhouse and bring electronic evidence in until a week or two ago. So they've gone almost 5-6 weeks without even talking to their client to gather the necessary records and information for defense. That's how bad this defense is going. They're busy raising money on the PR circuit, busy building a QAnon audience, rather than actually doing their job as defense lawyers. And again, Pierce has no experience that I know of in extradition of any kind. No experience in state criminal defense that I know of, except maybe his own. I mean, I know there was some potential charges against him, but nothing otherwise. And so they filed the state court judge is going to be like, you filed something that's frivolous on its face. You failed to cite controlling governing authority on this when it's over 41 years of governing authority from the U.S. Supreme Court. That in fact, this exact defense cannot be raised in this exact case under U.S. constitutional law. So sadly, we're seeing more evidence of what happens when you have incompetent defense lawyers running a case. And unfortunately, so many people on the right are happy to embrace their own personal Avenatti that not enough people are raising questions about it. And it provides further ammunition. For the reason for my concern and other people's concerns was things exactly like this. And I had other defense lawyers who read this write to me and say, this is just a complete joke. This is becoming an embarrassment. And this is going to continue to be an embarrassment as the process unfolds, unless John Pierce is no longer involved in the case. And so, it continues to be a problem. It's similar to like, Lynn Wood's defamation threat, where he says, hey, I'm going to sue you, Joe Biden, for saying my client's in a militia, forgetting that his own co-counsel that he picked, John Pierce, went on national TV and compared Rittenhouse to a militia, cited the militia statute as the basis for his actions, and compared him to the American militia. So good luck with that. This is what happens with incompetent lawyering. And unfortunately, the right's going to, people like Michelle Malkin are out vouching for him and on the fundraising record with him. It's an embarrassment. The right has embraced their own version of Michael Avenatti, and they're sticking their head in the sand, pretending that that's not what's happening. And Rittenhouse's life is the one who's going to suffer the consequences for this.
What is the, what are the next dates?
So the hearing, I believe, is this week. Actually, I think it's this week. I think the hearing was scheduled for this week because they had to submit the brief last week. They did it. Maybe the technical side he'll take a look at. There may be an argument, but what happened is their technical argument, they devalued it by making frivolous argument. He breached the ethical code. You have to cite governing authority on the issue, and he didn't. He didn't cite any of it. He didn't even show awareness that there was a difference between interstate extradition and foreign extradition. He didn't even say there was a awareness of the constitutional provisions that were applicable in this context. It's just embarrassing.
Well, and so okay. So if the hearing is this week or next week, whatever, what time frame is there going to be for a decision on this, and then what happens?
I think the judge will issue a decision at the hearing. If my suspicions are right that they've been telling Rittenhouse that the president's going to pardon him after the election, then they'll appeal that denial and just delay the process, and Rittenhouse will rot in jail longer. And just to remind folks, Trump, the president of the United States, cannot pardon people for state crimes. So if that's what he's being told a lie. And
this entire debate right now is on the extradition and not anything on the substance. It has no impact on the substance or on actually moving forward.
Correct.
What do they have to do to get him out now? The extradition is intricately related to whether or not he can post bail.
He can't get bail while he's under the extradition warrant provisions. If you're charged with a first-degree homicide, you can't get any bail at all until you have been extradited. So he's going to rot in jail until this process is decided. So they may drag it out until January or February, be in jail 5-6 months by that point. And then he'll lose the extradition, and they'll argue for higher bail because he fought extradition.
He's going to lose the extradition, meaning he's going to be brought to Wisconsin.
Where they already told him they're going to put him in an adult jail where his life's already been threatened.
Okay, and then hypothetically, you get to Wisconsin. What do we know? What the bail provisions would be there? Would there be bail?
They've already set at least a $2 million bail on the case, and my guess is the prosecutor will ask that it stay at least that rate, if not go higher. Now they'll be able to cite the Chauvin case to argue, hey, Chauvin got $1 million bail, so why can't we get $1 million bail? And then there's argument for that. My greater concern is that they're blowing through the cash so that they won't use that money that they've raised, over $2 million, for any bail. So
and it is Wisconsin that has the bail but no bond provision, correct?
Yeah, yes. So in Wisconsin, yes. In other words, the way bail works is the way to think of it is it's got to be real cash, real collateral. You don't have bondsmen. So it's not a 10% deal. You got to come up with the whole cash.
So now I'm going to summarize this because I think it all finally clicked together. Rittenhouse is fighting extradition to Wisconsin because Wisconsin has less favorable bail provisions. Whereas if he in fact,
no, and he stays in Illinois, he can never get bail.
Okay. So this is going to be a stupid question then. Why even fight the extradition?
Correct. That's what a lot of people wondered. Like I said, unless you're going to come up with a creative argument to politicize the case, do it out of the gate, do something creative, make people second guess things, highlight the self-defense argument, etc. Unless you're with a legally credible argument to the court system respects you. So that even if they don't agree with you, say, okay, this is creative, this is unique, this is smart, I see this case from a different context. This is going to be argued at the high plains. Outside of that, there was no and to buy time to raise money for bail. There was no reason to do this unless you're convinced of something crazy, like you're going to be the next chief justice, like the president can pardon people accused of state crimes. Unless you think
I don't want to think that I've oversimplified something to the point of confusion. There is no this is a lose-lose. They're losing on time. If they succeed on not getting extradited, they're stuck in Illinois, which has less favorable bail terms.
Mm-hmm.
And if they fail, they've wasted all the time, they've wasted all the money. They go to Wisconsin, assuming he's stuck with $2 million cash or property bail. Whatever money they've raised now is going to have been burnt for 2 months worth of litigating the extradition. And he's going to have that much less of it to actually post for the bail if and when he gets extradited to the better jurisdiction, regardless.
Correct. I mean, that's where I was. The rumor that I heard that seemed to make sense was if you're trying to buy time for the president, if you're trying to buy time for a pardon.
But nobody could make that much of a fundamental, basic mistake in strategy.
You wouldn't think so. Let's put it that way. Put it this way, it wouldn't be a surprise if that's what comes out down the road.
Okay. So we'll see where that goes, and then we'll maybe be talking about it next Sunday.